All right. Hello, everybody. I know we have a few more people who will trickle in, but we'll get started very, very shortly. It's really great to see you all. And just as an introduction, I'm Athreya Mathur. I work as the Director of Legal Research at the Center for Art Law. And thank you so much for attending our Legacy and Estate Planning Clinic and spending the evening hour with us in New York. Now, before I introduce you to our wonderful, wonderful speaker for this evening, I will let you know a little bit more about the Center for Art Law as per usual and let you know what all we do. So we are a Brooklyn-based research and education nonprofit, and we're dedicated to offering resources and programming to advance the arts and law community. So through our website, our newsletter, our events, we disseminate information and we try to keep our audience updated on everything art law. So whether it's news, publications, cases, you name it, movies, podcasts, the center tries to cover it. But of course, this doesn't begin to describe everything that we do. So I'd invite you to take a look at our website and subscribe to our newsletter if you haven't already to receive updates and to see what else we have planned for this semester and for the rest of the year. You can also consider becoming a premium member, and a lot of our members are here as well, and we receive tons of offers and discounts and free access to our events, access to our case law database, our articles, and very, very importantly, the recordings and archives of all of our past events. So just saying, a lot of benefits and a lot of information in this space is available, and we hope that you all will use them and take a look at just some of the work that we have been doing. We do have a couple of events coming up this summer as well. We will be having a workshop on moral rights, and just next week, next to next week, we will have a bootcamp training for attorneys wishing to specialize in artist-dealer relationships. This will be an in-person event in New York. And we also have a couple of seats reserved for artists and dealers and gallerists. So if you are an artist or a gallerist in New York and you would like to attend, please reach out to me and we would love to invite you to this program. And we will have more events coming up as well that will be available on our website shortly. But a couple of housekeeping items for today. The program is being recorded for archival purposes. So please, we would love to see you. Feel free to keep your cameras on, but your microphones muted for the moment. Once the video recording is available, I'll be sending that across along with a handout for the session and a survey for the program as well. If you have any questions for our speaker, we will have a short question answer session, so you can put them in the chat box. I really do invite you to send in your questions and comments. We always appreciate an interactive session. And as a note, that this is our clinic program for the evening, and we have short introductory remarks, after which we'll go into the consultation sessions for those of you who have opted in for those consultations. I will give more instructions after we are through with the keynote presentation. And finally, I am very, very excited to introduce you to our speaker for today. We have Candace Dellacona. She is a principal and shareholder in Offit Kerman's Estate and Trust Practice Group. She works very closely with different generations of family members, and she constructs wills, addresses different clients' needs and goals to protect financial assets, mitigate the burden of estate taxes, and a lot more. You can read all of the things that she has worked on in the handout, which will be sent across shortly. But without any further ado, let me hand it over to you, Candace. It is wonderful to see you. We are so happy to have you for today's session, and thank you for taking the time out to be here. And so sorry, I think you're muted.
Thank you. I hope I am in sharing mode, and let me just make sure that I am. Does that look okay?
Absolutely. Thank you.
Perfect. So I'm really happy to be here with all of you today, and I hope that this information is practical and useful for you. My goal is, anytime we talk about estate planning, it is not doom and gloom. It is not talking about death and dying and disability. It's more about empowerment and maintaining control, particularly for artists when your work is who you are, which is why we're talking about really what your legacy is when it comes to your art. So, when you think about estate planning in general, I think people focus on the end, right? And thinking about when you're not here anymore. I think the best place for you to start when you're endeavoring to get into a conversation with a professional regarding your estate plan is to think about what you have and where you'd like it to end up when you are not here any longer. As artists, you well know that your work will live beyond you. And that is the hope as an artist, that you're leaving something behind by way of a legacy or the art that you're putting out into the world. And the reason why anyone, artists, or those of us who are not so talented, think about creating an estate plan is because a lack of estate plan means that there is no organization, and it leads to confusion, hurt feelings, legal issues, and all of the things that go along with it. I mean, you can watch any number of your streaming services as it relates to succession and all of the drama, and usually an estate plan is part of that if it's not planned well. So what you should think about when endeavoring to discuss with someone your estate plan, it really is about maintaining your control and having a well laid out plan that is orchestrated and leaves behind the way in which you would want things done, which makes it easier for your loved ones. So the first thing I want to talk about, because we're really talking about trusts, is what is a trust and how does that differ from a will? And I think that that's probably a good place to start. So when you think of an estate planning document, most people think of a last will and testament. And a will is a document that can direct where you want your assets to go, who you want to be in charge of your art for certain. But a trust is a will substitute. And a lot of people say, why would I want to substitute my will for a trust? Number one is probate. So wills are documents that have to go through the court system. They are not legal until a court says they are legal and they are to be effectuated. That process is called probate, proving one's death, proving that the will is legal and it meets the requirements of the state in which you signed the will. So the probate process, you've probably heard about it. It's something that most people want to avoid. The other thing with a will is that it's entirely public. It's published in the court. So you could literally go down to New York County Surrogates Court and pull James Gandolfini's will. It was public. It was on the cover of the New York Post when he died. It is, required to be public. So literally anyone can pull, all of your wishes as it relates to your legacy. And often those instructions are very tender and they're private. And then the other issue is that a will is not legal till you're gone. So naming somebody as an executor during your life really means nothing. They're not the executor until a court accepts your will into probate and appoints the person. The other downside of a will is that oftentimes when people age, they get sick first. There are periods of incapacity. And so a will doesn't really address that. A will is literally a document that directs where your assets to go once you are gone. And so a revocable trust is meant to take the place of a will for all of the reasons or the downsides of a will. Probate's avoided. There is no court process. It's a contract that you enter into with your future trustee to take over for you when you no longer have the mental capacity or upon your passing. So a revocable trust works during your life. It is private. It doesn't get published anywhere, even after you pass away. It is like a contract that you have with another individual. No one is entitled to see that trust instrument. It's also effective during your life, meaning you don't have to wait until you pass away, or your loved ones don't have to wait until you pass away for the document to be effective. You establish a trust during your life over which you are your own trustee. and it will manage those assets during your life and direct where those assets go upon your passing. So it works before death and after death. It also survives incapacity. So with a will, it doesn't consider incapacity because the trigger date is death. With a trust, you can say, look, upon my incapacity, when two doctors say I don't have the requisite mental acuity to manage my assets, my best friend, my sister, my daughter, whomever can step in to my shoes as trustee and manage my assets during a period of incapacity. So it's a much more flexible document. So those are sort of the high points of the difference between a will and a revocable trust. Does a will still work? Absolutely it does. It directs where your assets go, but it's not the most efficient document. The other thing I'm going to say, which is not on this chart, is, we learned a hard lesson as trust and estates attorneys after COVID. Our court system collapsed. It quite literally collapsed. We are still dealing with delays in the surrogate court from COVID, which is unbelievable and inexcusable and all of those things. But nonetheless, we're still dealing with those issues. And knowing that a revocable trust is in place means there's no delay. There's no waiting for a court to act. Often probate can take years. And if there is a contest, a will contest, which is litigation, it could take many years. So it's to be avoided if possible. And that's really the difference between a will and a trust instrument. So, when we talk about the basic trust, we are talking about a revocable trust. So a revocable trust is an entity that can hold your assets during your life, right? That can be your paintings. It can be your catalog of songs. It can be a brokerage account, a bank account. Whatever assets you own can be held and titled in the name of the trust. And this type of trust, because it's revocable, it's still yours. You can still make changes to the trust. You can still take assets out of the trust and add assets to the trust. You purchased a co-op, it can be put into the trust right along with your bank account or your brokerage account, right along with your song catalog. It's just an entity that holds your assets. So during your life, it's extremely nimble and flexible and can change as your life changes. Right now, you may be single. In 10 years, you may have a spouse and may have children. And a trust can be amended and modified to reflect your current situation. And that's one of the best things about a trust. We have amendments all the time. I'm actually working on the 7th amendment for a client who's in her 80s. So things change over time. Relationships change. Assets change. So it's really nice to have a super flexible document that can change with you. So it's revocable during your life and it becomes irrevocable at death. The reason why is because we don't want other people saying what happens to your assets when you pass away. You're the one that sets the table and says, this is who inherits from me and this is who is in charge. That's why it's irrevocable when you die. So it sort of acts like a will after you pass away. So that's sort of like the basic, if you will, about a revocable trust. Now, artists have special considerations. You have a legacy that is different than just a brokerage account. The artists that we represent often come from families that may not have the same knowledge, if you will, about the market where their art is perhaps offered, if there's a market. And, artists also don't necessarily share the information with their families about certain dealers that you're working with or gallerists. They don't know about pledge agreements. So you have sort of a lot of specialized sort of needs as it relates to your own legacy as an artist. And so with a revocable trust, you really can kind of create the infrastructure for your loved ones, whether they're artists or not, to guide them and provide the information about your art, about what it's worth, about who the right people are to talk to upon your incapacity or upon your death. A document itself can really almost provide like a playbook for those you trust to effectuate whatever your goals are. In the trust instrument itself, we can actually appoint an art advisor. So, for example, in a revocable trust, you are your own trustee during your life, and we've directed upon your incapacity, your sister is your backup trustee. You trust her, she's an accountant, she's responsible, she doesn't know the first thing about art. So you can appoint an art advisor to help your sister. And that appointment can be in the trust instrument. So we are at a place with a revocable trust where all of the information can be contained in this one document. And it can change over time. So as I mentioned in the last slide, let's say you have an art advisor who's amazing and she's 73, and 25 years from now, she may not be around. So you can update that document to make sure that the next person can step in. The trust itself can hold assets and manage assets coming in. So I mentioned here that if you have royalties, I have a client who is a writer and she wrote a book 25 years ago that is still selling a number of copies internationally. Her royalties are paid to her trust instrument. And so her trust instrument can manage all of those royalties. And upon her passing, will continue to manage those royalties. So again, it's a really kind of flexible legal document, an instrument that can be used before death and after death, and very specific to whatever your art medium happens to be. In terms of, the trust itself, a lot of people say, what is a trust? Like, I don't get what it is. I try to tell people it's like a vase, it's a vessel that you can put anything in. And if you think about a trust and what it is, I say a vessel or a cup, and you literally retitle the asset in your cup. So, for example, you are a sculptor and you have your art. Your sculptures are exhibited at a gallery. They are in your own studio. They're in a number of places over which you still have ownership. How do you transfer a sculpture into a trust? Well, we do an assignment. We basically say, this asset is now part of this trust. We acknowledge and tell the insurance company that this asset is now in the trust. And so the trust and the way you add it to the trust is just by changing title, ownership on the asset. For a co-op, it's changing the stock certificate from Jane Smith as a person to the Jane Smith Trust. That's how you add an asset into the trust. When you create a trust instrument, you are the person establishing the trust. Some states call it a trustor. In New York, we call it the grantor, the creator of the trust. And when you create the trust, it's, again, you're setting the playbook for how your art is held during your life and upon your death, or when you're incapacitated, if that is the case. The grantor, meaning you as the creator, you are also often the trustee. You're the one in charge. So when we have married couples, sometimes we'll appoint spouses as co-trustees to share the load if necessary. Not always necessary, but if you're a single person, you are in charge of your own trust instrument. You get to decide what assets are added to the trust or taken away. So for example, let's say your trust is holding a painting, and the painting is going to be licensed for printing, and you receive a payment for that printing. The income that's received is still payable to you, but it goes into the trust, and you are the trustee and the grantor, so you are totally, continually still entitled to whatever income is received from an asset in the trust. In the same way, if you own a piece of property and you have a tenant on that property and they write a check for rent, it's still reportable to you. It is still yours. So the trust itself doesn't really create a separation, if you will, between you and the asset. other than just being the container that's holding it for you, the organizational entity, the vessel. And while you're the trustee and while you have capacity, you have complete control over whether that asset continues to remain in the trust or is taken out or is gifted away. So your control over the asset does not change. And with this trust instrument, as I mentioned before, you name a backup for yourself because life is unpredictable and all of this planning is contingent on your health and what will happen to you in the future. So you can really set the stage for whom you choose to be a successor to you as a trustee. That is the person that you trust. There's a reason why we call it that, to take over and step into your shoes and make financial decisions for you while you're alive to manage whatever those trust assets are. So the successor trustee could be your sister, the accountant, whom you trust. And in that instrument, you can also name an art advisor. And that art advisor can help your sister, the accountant, manage the art that's in the trust. Your sister can manage the brokerage accounts and sell your house and rent out your apartment, but that art advisor can be there waiting in the wings to provide the advice and the art specific guidance that is needed to properly manage your art. And that is very specific to artists. I'm currently working on a trust for musicians, and they have a few hundred songs in their song catalog. So we are retitling every song from the artist into the artist's trust. And so the song and all of its rights are within the trust, but the creator of the songs controls everything related to those songs. So nothing changes, no rights are taken away. Any income received continues to be received. And what we've also done is we've put an advisor on waiting in the wings in case this young man is not able to manage his song catalog, who understands the music industry, who knows who to deal with and who not to deal with, and who understands the value of what is in the trust, and knowing that this song may have a lot more value than this song. And this entity is not an entity that you want to license that song to. So the guidance that you can provide to your advisor or your trustee can really be expansive. We've gone so far as to basically draft almost an instruction within the trust instrument itself as a guide for that art advisor to inform them of everything that needs to be done with respect to that medium so that it's properly marketed, it's properly preserved, and it's properly valued and the value is maintained. So I think it's really important for people to think about a trust as not giving up control because you're creating a trust, but maintaining the control, and really maintaining the control in a way that you can't do if it's in your own name. You can't put that sort of guidance in a will, because if you put it in a will and you're still alive, the will doesn't have any control over how that art is managed during your life and while you have the lack of capacity to manage those assets. So this trust instrument can really provide you the infrastructure to organize if you don't have the ability to do so at a later date. And I think, I covered this, but I want to be clear that everyone hears it. During your life, you are the beneficiary of any asset in that trust. In fact, the way that a properly drafted revocable trust is laid out, it specifically says the only beneficiary of this trust instrument is the person who created it. It is not for anybody else. Now, are there circumstances where we add other people? Yes, because if you're an artist and you have a minor child and money is being earned off of that art and you're supporting your child, you probably want your backup trustee, if you're incapacitated, to pay your child's university tuition, right? But it prevents people who shouldn't be benefiting from you. So it is clearly articulated in the trust instrument who those assets should support. It could support your spouse if you acknowledge your spouse. Same with your minor children. But anything beyond that, while you're alive, your art is supposed to be used by you, right? And you should benefit from your art. I've also drafted trust instruments that provide significant direction to clients who create a foundation for their art. I work with a noted artist here in New York. She's an international artist, and she's created a foundation that has political leanings, and we are funding the foundation with her art. Now, many of her family members are not informed as to the value of her art and what can be done to generate revenue to support her foundation. So we have gallerists and art experts who handle that piece of it for her, and it's all articulated in her estate plan, which is pretty remarkable. I think that when these trusts were created for the first time, I don't think there was a contemplation for what we currently use the trust for, but that just goes to show you how flexible and nimble these documents can be and really can address any asset that anybody has. In terms of the trust itself, we've talked about this a bit. Trust can be funded with any asset, your copyrights, your trademarks, your royalties, any portfolio, any art, any sculpture, anything that's tangible, money in a bank account, brokerage account, stocks. Let's say you've created an LLC for your art, which is a really smart thing. We can put the membership interests of your LLC into your trust. So your LLC is still in place, but the LLC membership interests are in the trust. So probate would never be required for that LLC. The LLC still operates how you want it to operate, but it's just moved under the umbrella of your trust so that is never public and it does not have to go through probate upon your passing. So it's really flexible and can own any asset. One of the assets that it can't own would be international assets. So if you own a house in Greece, Greece is not going to acknowledge the United States trust, right? So it's really important that when you fund your trust assets, you're funding it with assets that are, for the most part, in the US. And of course, that's because of our Constitution, and that our Constitution basically says that we only have jurisdiction over assets that are here within the country. But let's say, for example, you're a New York City artist and you inherit a cottage from your grandmother in Maine. Your New York trust can own your cottage in Maine. Just because it's in a different state, you can just still have that one trust that could be the receptacle for those assets located in the United States that are characterized differently. And I'm sure I'll have questions about that, but we can talk about that when we're done. Okay, so I think trusteeship is something that really needs to be highlighted, and I think that what most people struggle with when they're creating an estate plan, whether you are an artist or you are a hedge fund manager or a teacher or a doctor, is who's going to manage everything that you've worked so hard to create or accumulate in your life? Who do you trust? And, I think that particularly when you are in a creative world, it is such a personal and tender expression of who you are that in some ways it's even more important who you choose to manage what those assets may be when it is an offshoot of your creation. And in doing so, it's really important for you to think about who that person should be. And so I mentioned and used the example of your sister who's an accountant and she's brilliant financially, but she doesn't know the first thing about what you do or why it matters or what it means to the world. It's really important that you have somebody that can provide that kind of insight. And it doesn't always have to be that person. And that one person doesn't have to be able to do everything. You can bifurcate those roles. And I think that that's really important for you to think about, because when you think about what your legacy is, it's specific to you. and your art, and your accountant sister may not be the right person. And there is a way to do it that is sort of kind, where you are giving your sister or letting her off the hook by saying, I don't think you have to worry about that. I'm going to provide you with someone to help you. So it's never looked at, if it's framed the right way, as taking away control or power from your loved one. It's providing them with a resource. And so, when you think about the person that you're appointing, they are a fiduciary. So if your art advisor is a gallerist, I want you to think that through about what their obligation would be to you and what their obligation might be to their own professional, orientation and what they do for a living. I think that trust has to be the threshold question. It's not so much who it is, but can you trust them? Because they are a fiduciary. And having a fiduciary in place really puts upon them a level of responsibility that means when you're a fiduciary, you have to put someone else's interests ahead of yours. So if you're appointing your gallerist as the art advisor, that gallerist is supposed to put your asset, your art, and the interests related thereto above their own interests. So think about who you want to put in that position of trust that has that ability to do that. It's not an easy ask. A lot of times I hear people, clients say to me, gosh, like it feels like a burden. I'm asking a lot. You are, but I'll tell you, most people, when they're asked to serve in that fiduciary capacity as a trustee or an art advisor, it's a position of trust. And so I think most people, the knee-jerk reaction is they feel honored that they are trusted with such a position. And it's worth talking to them about. They may say, gosh, this isn't for me, or I don't know that I'm going to be in the US in 5 years, and maybe I'm not the right person. So it's definitely something you should not surprise someone with. Don't appoint someone as an art advisor and not tell them. Don't appoint someone as a trustee and not tell them. It's really important that you have the conversation, and the conversation keeps going, because like life, things change, and it may not be the person that you want forever. They may have their own considerations when it comes to dealing with someone else's estate. So things like distance, if they move far away, death, obviously, disability, we call them the Ds. If any of those things happen, you have to turn around and decide, is that fiduciary that you appointed 6 years ago still the right person? Maybe the answer is yes, and maybe it's no. But having this revocable trust instrument that is nimble is really helpful for that reason. So, it really can be flexible and reflect your life. The last sort of subtopic I want to talk about is an art-specific trust. Now, this is a little different than the revocable trust that I was just talking about. An art trust is an instrument that just holds art. And the people that use an art trust are usually people that have art with significant value, where they want to actually gift artwork or their collection into a specific trust. And a lot of people say, like, well, why would you do that if you have a revocable trust? Do you need both? The answer is you don't need both. A revocable trust is an estate planning tool that is extremely flexible that everyone should use. An art-specific trust is generally considered irrevocable, meaning you're giving it to the trust and it's out of your estate. So it's really done for tax purposes. So when you hear about people talking about an art trust, it's really a trust in which you are giving away that art and you're giving it to the trust instrument for purposes of estate planning as it relates to taxes. So for example, I have a client who is the daughter of a pretty prolific art collector. And the daughter received this painting, and it's worth quite a bit of money, enough so that it will force her own estate to become taxable. So she's gifting that art, which she can still enjoy, to the trust instrument, and it will never be part of her estate and therefore taxed. So this type of trust really becomes operative when you're talking about significant collections. In the same way, you can, articulate in a revocable trust specific, ways that you'd like it managed, how the art will be displayed, how it will be licensed or sold or donated. The artist that I'm dealing with right now, who has the foundation, I mean, she has an art trust and a revocable trust as well. And we have a lot of information in her art trust about the way in which she wants her art to be used very specifically. She has a lot of very strong political beliefs, and some of the institutions that would traditionally display her art, she does not want her art displayed there, because she has different political leanings. And we have articulated that in the art trust. So it really can kind of run the gamut about everything related to your art and what is important to you and the way in which it's preserved, and how your legacy is addressed after you are no longer here. Let me just go to the next slide. Okay. I hate doing this because, I don't think fear is a great motivator, guys. I think, when you think about, do this because I really think that focusing on the positive rather than the parade of horribles is enough to have you understand why an estate plan is important. But I do want to give a couple of cautionary tales. Prince and Aretha Franklin are really good ones. Aretha Franklin, I don't know if you guys know, she didn't have an estate plan, which is crazy. And you think about this person's legacy and her beautiful music that she left behind and all of her publishing rights. And, it's such a prolific legacy. And if you would believe it, somebody found a partially signed will in a couch cushion for Aretha Franklin. She had all of these professionals surrounding her, and nobody helped her set up her estate plan properly. Same with Prince. Prince died young, and he has a huge estate in Minnesota. The estate is still going on. He died, I think, 10 years ago. So, those are two sort of cautionary tales of what could happen when a plan isn't set in place. And then, Andy Warhol is the opposite. Paul Morrissey is the opposite, right? Where people that really thought about what their legacy is and should be and what they want it to be in the future, set forth really what their legacy is going to be forever, long after they're no longer here and their family is no longer here. So having a trust could have helped Prince and Aretha, in the same way it helped Andy. So I just think it's worth mentioning. And again, not, like I said, fear is not a great motivator, and I'm not a believer in it, but I just wanted to mention that. So, what do you do next? Like, okay, great, I have all this information, how do I even begin? So what I always tell people is you start with a list. Write down what you have. You have your 401k or your IRA, and, back when you worked in your corporate job, and then you have your collection, and you have your savings account and your checking account. So make sure you know what you have. That is the first step. And then I really want you to think about, who do you trust? Who are your people, right? Who are the people that you could say, I know that they would carry out the wishes that I've, set forth in my estate planning document. So your people and who you trust. And then who you want to benefit from all of your work, right? Whether it's a monetary value or loving your art in a way, who do you want to be left with whatever it is you're putting out into the world when you're no longer here? So the list, the people you trust and who you love, and that's really the way to start. And then once you have it in place, keep it updated. Just take a look at it once a year, just flip through it and make sure all the people that you've named are still your people. And, think of the D's if you've already set it up. Death, if somebody in your will or trust has died, gosh, I should probably replace them. Disability. If you've named your mom and now your mom unfortunately has Parkinson's, she's probably not the right trustee, right? Distance. If they've moved away and they now live in the UK, I don't know that they'd be the right person to deal with your estate or to be your successor trustee. Divorce. If you appointed your sister-in-law and she's no longer married to your brother and you don't have that same relationship, it might make sense to make some changes. So when those D's come up in your life, take a look at your estate planning documents and make sure that they're reflective of your current wishes. And I think that's it.
All right. Thank you so much, Candace. We really, really appreciate it. This was a very, very comprehensive presentation, and I think it sets a really, really good base for the next half of the session, which will be the Zoom consultations, which we'll go into shortly. I do want to give a chance to have at least some of the questions answered. We're running a little behind time, but if it's okay, I will maybe ask you two or three of the questions that came in.
Yeah,
So one of the questions is about the taxes and how do taxes work with revocable trusts? Where and to whom do tax liabilities accrue?
great question. It doesn't change. So a revocable trust is a non-entity. It flows through you. So whatever tax return you're filing now, when you create a revocable trust, it's exactly the same. There's no additional taxation and no level of taxation because it's revocable and amendable.
All right, thank you so much. In other question that we have, how many people down the line should your estate cover? Do
Mm.
does it have to be the artist and their children? Should it include their children afterwards? What are your thoughts?
Great. That's a really great question. And it's like the perfect lawyer answer. It depends. So, you know, I have clients that say, if not my children, then my grandchildren. And if they're not here, then I want this institution to inherit. And if that institution isn't here, then I want this contingency. So it really does depend. I mean, I like contingencies. I think it's smart to have contingencies so that nothing issues to the state. So to the extent that you know who you'd want to inherit from you, and who you want to be the custodian of your art and your legacy now, we draft it. So, if you know it, we can draft it.
Thank you. The next question, what happens in the case of a breach of the terms of the trust? Who's in the position to dispute the execution of the trust?
Such a great question. So, there are different ways in which a fiduciary obligation can be breached, right? So during your life, if you don't have capacity and a trustee is acting outside the scope, that's a tough question. There are a lot of predatory actors in the world. As people age, especially now, we talk a lot about the sandwich generation, and especially in New York City, there's a lot of isolation. But what I would say is future beneficiaries can pop their heads in and say, "What's going on? Like I was supposed to get X or Y, or the trustee is now driving a super fancy car and I don't know what the story is." So you actually can bring the action into court, even though your trust is outside the court, because you can raise your hand as a beneficiary or as a successor trustee and say, something's not right. The artist is now incapacitated. In fact, there's a pretty famous case that you guys probably know about, an artist here in the city who's dealing with something similar. And somebody raised their hand and said, "Hey, court, we need you involved because there's something going on." But that issue is universal, and it's not specific to a trust, right? Making sure that whatever your wishes are properly effectuated.
All right, thank you so, so much, Candace. I know there are a good few questions in the chat remaining, but we are running a little behind time with the consultations, so we might move into the other half of this session. To those of you who would like to stay back and maybe we'll try to answer some of these questions, please feel free to. But this would conclude the first half of today's program. So thank you so much for attending, and we really appreciate it. Candace, once again, a big, big thank you for being here for the presentation and
My
for
pleasure.
staying and answering the